A high court in Akure, the Ondo State capital, has nullified the creation of an additional 33 local council development areas by the administration of late former Governor Oluwarotimi Akeredolu. The presiding judge, Justice Adebusuoye, who delivered the ruling on Thursday, declared the creation of the LCDAs unconstitutional and illegal. Recall that the Ondo State House of Assembly had passed the bill for the creation of the 33 additional councils on August 15, 2023, which the former Governor Rotimi Akeredolu signed in September last year. The 33 LCDAs were to coexist with the 18 local government areas, bringing the total number of local councils in the state to 51. To further discuss this, I'm joined by legal practitioner Taiwo Ojumu. Hello, Taiwo. Thank you so much for joining us.
Thank you for having me. Good morning.
All right, Taiwo, can you tell us what was the legal basis for Justice Adebusuoye's dissolution of the additional 33 local council development areas?
Right, thank you. Yes, at the moment, I have not been able to read the full context of the judgment, but from what we know, a group of leaders from Akure is in the north central district of the state, who felt aggrieved that the creation of the 33 LCDAs did not favor them, that they were shortchanged. They went to court. They took the state government, the Attorney General, the Speaker of the House of Assembly, and of course the House of Assembly to the court, asking that the court should nullify and set aside the creation of the LCDAs on ground that it did not comply with the provisions of the 1999 Constitution. Yes, that was basically the ground for the matter in court. Yes.
All right. So, in as much as you haven't read the full context, but would you say that the necessary procedures and guidelines, were followed in the dissolution process?
Well, the thing is that from what we know, I've read in sketches the ground for the dissolution by the judge. The thing is that if you look at the provision of the provision of the Constitution, particularly section 7 and 8, particularly section 8, speaking of the creation of new states and the adjustment of boundaries, there are procedures that are to be followed strictly in the event that that new local government will be created. And one of such procedures, would be to carry out a referendum by two-thirds majority of the people of the area wishing to be, the area where the local government or the council is to be created. And from the fact that we have before us, no such procedure was followed. And so I understand that the court has said that the creation remains inchoate and that those SDs cannot function, having not strictly complied with the provision of Section 8 of the Constitution. So yes, from the fact we have with us, those procedures were not strictly followed. The provision of Section 8 of the Constitution of the Federal Republic of Nigeria was not strictly followed. But I believe that there will still be appeal. Just this morning, the Attorney General of the state released a press conference to his media aide, stating that it will take time to study the ratio of the judgment or the ruling of the court, and so that they will know necessary action to take. But I believe that we have not seen the end to this.
Okay.
I have very strong reason to believe that the matter will go on appeal.
All right.
But
all right, Taiwo.
Okay.
Go ahead.
All right. There's a part that actually struck me. There's actually a novel area which for me is the crux of this particular issue. For me, the fact that the question of whether a governor can assent to a bill outside the state, because one of the grounds, of course, not the major ground for the setting aside of the creation of the SDAs, as stated by the court, is that...
did the governor have the constitutional power to do that?
No. The point I'm making is that the question will be whether or not the governor can effectively sign or assent to a bill outside the shores of a state. the court has said now that the governor cannot assent to that. The fact that the governor assented to that bill outside the shores of the state, that is in Ibadan, makes it inchoate, and that it runs contrary to any known law in the state and the country. But that part is a very novel area. It has not been tested in any court so far. So that part for me is striking.
All right, Taiwo. Now, how does this dissolution, align with the principles of decentralization, autonomy, and grassroots governance enshrined in the Nigerian Constitution?
Right. Now, the thing is that if you look at the rationale behind the creation of these LCDAs in the first place, it is chiefly to ensure that the development goes, that the rural part of the state actually experience some form of growth and development too, because the state is growing bigger by the day, and that the 18 local governments in the state cannot cater for the needs of the people. And so, for me, by way of personal opinion, the dissolution of the setting aside of this LCDs looks like some steps backward. Because it will mean a lot for the people of Ondo State. It will mean that those areas where people should feel the state presence might not feel that enough now, because it's like we are taking us back in time now. But that's personal opinion. That does not mean that the reason of the court is not sound. But like I said, I believe that we've not seen the end to this. This matter will proceed to the court of appeal, and perhaps to end at the Supreme Court. And the court at that point will be able to tell us, we'll decide on where to go from there. But by way of personal opinion, I feel that it's like taking us some steps backward.
Okay. Well, thank you so much, Taiwo, for speaking to us on this.
Thank you very much for having me. Thank you.